Good morning to people and who are watching from other places, and good afternoon as well. I would like to extend a warm welcome to all of you to this Contemporary Reflections on International Law webinar, jointly hosted by the OP Jindal Global University, Jindal Global Law School, and the Embassy of India at The Hague. We have with us a very distinguished set of academics and jurists, and we'll be discussing on the theme Practice Before International Arbitral Tribunals. But before I formally introduce the panelists here, let me request our collaborator, His Excellency Mr. Venu Rajamani, the Ambassador of India to the Netherlands, The Hague, to deliver his welcome address. Ambassador Rajamani, over to you.
Thank you, Raj. Good afternoon to all friends here in Europe, and good evening to everyone in India. It's a great pleasure to once again host a webinar in collaboration with the OP Jindal Global University. This is the third in our series, which we called Contemporary Reflections on International Law. The first two were focused on the International Court of Justice, and they included one webinar which was addressed by the President and Registrar of the International Court of Justice, as well as Judge Bhandari from India, who sits on the International Court of Justice bench today. The second webinar was on the contribution of Indian judges to the International Court of Justice and to international law over the years. The main speaker in that was Mr. Philip Couvrer, the former registrar of the International Court of Justice, and Professor Chimini from the OP Jindal Global University. And today, we have great pleasure in bringing to you the Permanent Court of Arbitration. We have here with us the Secretary General, Mr. Hugo Siblis, as well as a very eminent scholar from the OP Jindal Global University, Gudmunda Eriksson, not to mention Professor Rajkumar, who would be moderating this discussion. I see Dr. P.S. Rao has also joined us just now. Welcome, Dr. Rao. So our panel is complete. Let me just say that the purpose of this webinar series is to bring the best of knowledge and thinking about international law from The Hague to the legal fraternity of India. We believe that as India grows, as India emerges as a major power, as India continues to maintain its commitment to a rule-based international order, engagement of academic scholars and students in India with key legal institutions, especially those here in The Hague, are extremely important. The legal institutions in The Hague, as most of you would know, include the International Court of Justice, the Permanent Court of Arbitration, the Hague Conference on Private International Law, the International Criminal Court, the Hague Academy, etc., just to mention a few. Today's topic is, as mentioned by Dr. Rajkumar, Practice Before International Arbitral Tribunals. Our panelists will dwell upon them in detail, and I'm sure Hugo will also talk about how the PCA was the first global mechanism created for the settlement of interstate disputes. It is the oldest institution here in The Hague, which was established in 1899 after the first Hague Peace Conference, and it has currently 122 contracting parties. India became a contracting party soon after its independence in 1950. And India has now a host agreement with the Permanent Court of Arbitration, which we signed in September 2008. We were the fourth country to do so. We have also been having discussions with the PCA on the establishment of a PCA regional center in New Delhi, which we believe will greatly contribute to the building of an arbitration ecosystem, to the strengthening of the arbitration ecosystem in India. Since India became a contracting party, the PCA has acted as a registry in 21 cases involving India or Indian parties. There are currently 8 PCA registry cases involving India or Indian parties. PCA has also acted as registry in 3 interstate disputes involving India, which are the Indus Waters Kishan-Ganga arbitration between Pakistan and India, the Bay of Bengal maritime boundary arbitration between Bangladesh and India, and the Enrique Alexei case between Italy and India, in which a judgment was awarded very recently. Dr. Rao was one of the arbitrators, one of the members of the tribunal in that case. As far as today's panelists are concerned, it is with great pleasure that I welcome Mr. Hugo Siblis, the Secretary General of the PCA, to this webinar. Mr. Siblis is a career diplomat. He has served as ambassador of the Netherlands to France, to Monaco, and Andorra. He has worked in various capacities as in the Ministry of Foreign Affairs of the Netherlands. This is his second term as Secretary General of the PCA, and he has not just been rendering outstanding service to international law in this capacity. I'm very happy to say he is a close friend of India. He has visited India many times. We very successfully organized PCA India conferences several times over the last few years, and an online conference is under preparation even as we speak towards the end of November, which will feature a host of dignitaries. All the PCA India conferences have been attended by the Law Minister, by the Chief Justice of India, and by very distinguished legal personalities from India as well as from abroad. Dr. P.S. Rao, the other panelist today, is currently a special advisor to the Attorney General's Office of the State of Qatar and a former member of the International Law Commission. He has served as judge ad hoc of the International Court of Justice. And he has been associated with the Ministry of External Affairs in India for very long years. He's a veteran, and he was an institution in the Ministry of External Affairs when he was there by virtue of his legal expertise. He was also co-agent and advocate for the Republic of India in the case concerning the aerial incident of 10th August 1999 between Pakistan and India. He is an alumnus of Andhra University and the Yale Law School. Professor Gudmundur Eriksson is a professor of law and the executive director of the Center for International Legal Studies at the Jindal Global Law School. He's an alumnus of the Rutgers University, King's College London, and Columbia Law School. Professor Eriksson has served in the United Nations. He was ambassador to India till recently. He joined the Jindal University after his tenure as ambassador of Iceland in India, and he has served in many capitals such as Ottawa and Pretoria, other than in New Delhi. He was also a member of the International Law Commission and a judge of the International Tribunal for the Law of the Sea. And friends, Professor Dr. Rajkumar, who will be moderating this discussion, is the founding chancellor of OP Jindal Global University. He has studied in Oxford, in Harvard, in Hong Kong, in University of Delhi, and in Loyola College of Chennai. He has a large number of publications to his credit, including books, journals, and law reviews across the world. And it is entirely to his credit that the Jindal University is ranked one of the best universities in India today. It has been nominated as the best liberal arts school. Its law school, to which both he and Gudmundur are also associated, is ranked the #1 law school in India. This university is India's #1 university in social sciences and humanities, and it is in the top 150 universities, as well as the top 700 universities globally. So thank you very much, Rajkumar, for joining the Embassy of India in this wonderful initiative. And we look forward to working closely with you in the coming days. I wish all the panelists and the audience an excellent discussion in the next 1 hour and a half. Thank you very much.
Thank you very much, Ambassador Rajamani. One small correction: I'm the Vice Chancellor of the University. Our Chancellor is Mr. Naveen Jindal, who is the founding Chancellor and benefactor.
My apologies.
But it's such a pleasure for us at OP Jindal Global University and Jindal Global Law School to collaborate with the Embassy of India in the Netherlands to actually do this initiative as contemporary, conversation surrounding international law. I want to begin by saying that this extraordinary opportunity that we have in discussing the theme of this evening's colloquium, Practice Before the International Arbitral Tribunals, is largely because of the individuals who have accepted our invitation. The three of you are part of this discussion. So I am personally very eager and delighted to be part of this colloquium. Now, let me briefly introduce the theme of the colloquium itself, expounding on the founding philosophy of the Permanent Court of Arbitration. Jackson Ralston wrote in the first volume of the American Journal of International Law, and I quote, The newer fiction that national governments were sovereign beyond the ordinary gauges of right and wrong, and were their own courts of last resort upon the rightfulness of their actions toward other governments, subject only to the arbitrament of war, were measurably impaired, the signatory nations admitting fallibility and agreeing that, composed as they were of an aggregate of individuals, like their component parts, they might err, and that the question as to whether they had erred or not could fairly be determined by other human beings, perhaps no wiser, but certainly more impartial than themselves, unquote. So since the establishment of the PCA and the earlier conceptions of settlement of disputes among sovereign states, settlement of international disputes has come a long way. However, little did the imagination that arbitration is an effective way of settling international disputes wane. The ambition with which the Hague Peace Conferences organize arbitral resources, giving the touch of professionalism and even predictability to arbitration, continues to sustain even the days of permanent international tribunals. Today, the PCA has evolved into a modern, multifaceted arbitral institution that has competency and resources in both public and private international law to meet the rapidly evolving needs of the international community. It provides services for the resolution of disputes involving various combination of states, state entities, intergovernmental organizations, and private parties. Since its inception, the PCA carried forward the historical legacy of being an alternative to formal settlement of international disputes. Now, in recent times, international arbitration has advanced from an, and I quote, alternative to formal dispute resolution before courts to, in the words of Redfern and Hunter, and I quote, the principal method of resolving international disputes involving states, individuals, and corporations. This advancement has been credited to the increased globalization of world trade and investment. Given that several international treaties and statutes now contain arbitration clauses for the peaceful settlement of disputes, arbitration is no longer a mere alternative, but has become a more formalized and oftentimes a more preferred form of international dispute resolution. In fact, I would argue that there is so much that national arbitral mechanisms can learn from the PCA. With arbitration becoming the natural way of dispute resolution, the role of arbitrators become even more significant. As the phrase goes, an arbitration is only as good as the arbitrator. However, to keep up with the changing times and to ensure the continued efficiency of the arbitration process, arbitrators may have to move beyond their strictly legal duties and code of ethics. Decision-making, as some writers theorize, depends on a combination of the decision-makers' feelings and reason. Thus, arbitrators may well have to gaze into the crystal ball and approach each matter before them with a sense of modernism, futurism, innovative spirit, and interpretation. Therefore, this colloquium is an important platform to discuss the future of practice before international arbitral tribunals today and its future. Let me move to my distinguished panelists who are present here, and I'll start with Professor Rao himself. Professor Rao, today, in many areas of international relations, treaties generally provide for arbitration as a means for settlement of international disputes between the state parties themselves. Example, Article 84 of the Chicago Convention on Civil Aviation, 1944, and the Annex 7 to the UN Convention on the Law of the Sea. In most of such cases, provisions for arbitration coexist with or in parallel to formal mechanisms for the settlement of international disputes like international courts and tribunals. Now, how do you rationalize this aspect such that the spirit of the objectives of the parent treaty or statute is upheld? Professor Rao.
First of all, let me thank Ambassador Rajamani and you as Vice Chancellor, both of you dear friends. I have grown very fond of both of you for a long time under different occasions. We had opportunities to interact. And this is one more opportunity I hope will give us more of these opportunities to talk and deal with international law and its relevance and role in contemporary times. And I think arbitration has been conceived originally the method of settlement of disputes before anything else was talked about. That was way back in the European context, where wars have been very common. Settlement of disputes was very rare. And even if they were there, they were informal, not in the structured, international law-based, rule of law-based, or promoting rule of law in the process was not the situation. It was more an ad hoc and otherwise a very informal situation. So the Hague Peace Conferences took the idea put forward by the many members, the initial members of the Institute of International Law, if I may arrogate that to that source of originally which promoted this. In fact, they got a, you know, that Institute of International Law got the Peace Prize, Nobel Peace Prize in 1904 because of its proposal originally that was accepted by the Hague Peace Conference to substitute settlement of disputes peacefully by arbitration to war as an instrument to settle disputes. And now that has been done. The first and second Hague conferences have certainly brought this institution into play. It took quite some time thereafter, of course, until much later. And more recently, of course, I don't want to go into history because time is short. Arbitration has been named as one of the sources of methods of settlement of disputes in most of the treaties, particularly in commercial and bilateral treaties, where concession agreements have been entered into between private parties and states, like multinational corporations and countries like Saudi Arabia, etc. And in situations where the investment arbitration has now become a common feature. These are where, if there are two states or parties to a dispute in a treaty, even they normally, until a multilateral treaty system has come up much later, the bilateral treaty systems have only created the arbitration as a main method of settlement of disputes. And because then they can choose the parties, they can prescribe the necessary dispute at hand, because dispute can have many aspects to it, you see. So in the arbitration, through a compromise clause, parties can refer only that aspect of the case which they would like to be decided by the particular tribunal, which they want to constitute with their own, each one of them nominating one and the two at the moment, and then the neutralized person, arbitrator will be appointed. So this is a flexible method. This provides an opportunity for the parties, a great leverage in terms of what to do, what not to do, within what limits it has to be done, under with what law it has. For example, they can even prescribe the law. For example, they say we would like to see in this contract such and such practices being looked into for purposes of our discussion or our decision. So therefore, it has been a traditionally accepted method until first the League of Nations with the Permanent Court of International Justice, followed by ICJ with the UN Charter, and then, of course, law of this convention bringing in it, class permanent courts come into picture. In fact, this is the only other method and the most ancient method of judicial settlement. So, rationalizing it means it is the only thing that is available to states, preferred by states, and used by states. And now, in fact, the usage of the arbitration as a method, even when we have side-by-side permanent court, the International Court of Justice in the same peace palace, the Permanent Court of Arbitration, for example, has been rendering extraordinarily decisions on extraordinarily important issues. East Timor, Leste, and Australia, conciliation is one great example. Eritrea, Ethiopia, Boundary Commission is another example. Our own cases, which I already mentioned, are great examples. So therefore, I would think this is the most natural, most flexible, and most sought after, and otherwise highly current dispute settlement conceived as alternative to permanent courts, where the jurisdictional hurdles are quite hard. In other words, in the ICJ, you have to really sign an agreement or otherwise compulsory declarations have to be filed, and there are always disputes about jurisdiction. And ICJ generally is reticent to liberally interpret the limitations put on its jurisdiction, whereas arbitration can go a little better.
Thank you very much, Professor Rao, for really setting the stage for the discussion this evening, because one of the big challenges is this question of legitimacy, which I'm going to ask Professor Gudmundur. Mr. Siblis, in one of his writings, has argued, and I quote, that legitimacy is the cornerstone of effective dispute resolution, unquote. As legitimacy will increase, quote, compliance with decisions and awards, unquote. It has been stated that institutions like the PCA, more as a paradigmatic international institution rather than as a framework which provides the means, materials, and resources for arbitral proceedings, obtains outcome legitimacy. Now, to what extent do you think, Professor Gudmundur, does this line of argument blur the boundaries between arbitration and formal dispute resolution mechanisms, as the latter also hinges on institutionally obtained legitimacy, where the institution becomes the reason for legitimacy? Or is it that the legitimacy argument is one of the ways to rationalize the earlier said position, which Professor Rao beautifully articulated?
Well, yes, thank you, Vice Chancellor, and thank you, Professor Rajamani, for inviting me to participate in this webinar. And so nice to see my good friends, Ambassador Siblis. Well, to say nothing, as you say, about Dr. Rao, we've been together so many times. We spent 10 years together in the ILC, and before that, long before that, 40 years ago, we sat side by side in the UN and the negotiations for the Law of the Sea Convention. As you know, in the UN, India, Hungary, Iceland, India, many hours we spent together, and very many enjoyable times. Well, and thank you, Vice Chancellor, for starting us off with referring to this article from, well, the beginning of the 20th century, at the beginning of this era of the modern international dispute settlement. If there's anything we're learning from the crisis now, is that we have to reappraise existing procedures, and sometimes it's wise to go back to the basic principles, as you cited, as reflected in the passage you read out. And again, referring to what Dr. Rao was saying, we in the Law of the Sea Convention deliberately chose to have 4 different fora to settle disputes. We had the ICJ, the to be established Tribunal for the Law of the Sea, as we just heard, and plus 2 types of arbitration. Now, we have to remember what the climate at the times in the late 70s. It's fair to say that the ICJ had fallen into disfavor, particularly in states from the third world. As we heard in the last webinar from Professor Yusuf, that is no longer the case, happily. And secondly, states would maybe have been reluctant to turn to the ITLAS, another which was yet to be established, without a track record, you might say. And then again, in the course of time, that also has changed. So we have 3 really viable options for available to states. And I always say, the more options available, the better. Now there's a problem, you're kind of hinting at it already. You speak of juxtaposition, but the possibility of fragmentation of the law. And Dr. Rao knows that the report that the ILC prepared under our good friend Marty Kashianemi on this very question in 2006 addressed this problem. Well, as I said, I think this is the risk we are prepared to take. We don't think of this as a conflict, but if one of our good colleagues referred to this as yes, that's right. It's fragment. Is this fragmentation a problem that we're prepared to accept? I recall a good colleague, he spoke of a collective interpretive endeavor. And in fact, Professor Sean Murphy goes so far as to say, to celebrate the value of competition between international tribunals. Yes, so I see this is a kind of a start of the answer to your question, Vice Chancellor. But yes, the more general question is something that you might identify a crisis at least a perception of a crisis in the existing regime, particularly investor-state dispute resolution. And Ambassador Siblis and I and his colleagues in the PCA have been working under the auspices of UNCITRAL on these questions. One of the options we're considering very carefully is to propose systemic change, including the establishment of a permanent multilateral investment court.
Well, thank you very much, Professor Gudmundur, for that. Let me move to Ambassador Hugo Siblis. Ambassador Siblis, before I ask the specific question, I would like you to briefly reflect on your own, let's say, ideas about the state of the PCA. I mean, from where you stand, from the vantage point, how do you want to reflect on, what the PCA is today from your standpoint?
Well, thank you very much for this question. Before turning to it, let me first of all say that I'm very pleased to be able to participate in this webinar. We would normally have been Delhi for the third India PCA conference. So this is second best option. Let me put it that way. But I'm very pleased also with the initiative of the Jinal Global University and the Indian Embassy in The Hague to have organized this series of webinars, and especially this one where I feel most at home, because it is about arbitration, and this is what I have been involved with certainly for the last 8 years as the Secretary General of the Permanent Court of Arbitration. Now, in very broad terms, because asking about the PCA, you really ask for trouble, because I could go on for hours. But everybody knows where we come from, I think. It has been mentioned already also by Ambassador Ramonaji and also by Dr. Rao. And at that time, arbitration between states was an ad hoc affair. The Alabama arbitration notably, but also others. And so at the time, it was felt that the world needed a more structured mechanism to deal with settlement of disputes between states, because judicial settlement at the time didn't exist for lack of international structures under which those institutions would operate. So, well, like many conferences, it led to some compromises here and there. The PCA was established by some considered to be a disappointment because it had no mandatory jurisdiction. It was, according to some, only a list of arbitrators, the members of the court. And so at the time, it was the best possible outcome given the position of the 26 countries, mostly European countries, assembled at that time by the Russian Tsar. The 26 were the countries that were represented at the Tsar's court, and so no other countries at the time were invited. And basically his underlying motive was to create a mechanism that would help the Russian Empire to keep up with the Joneses in terms of armaments, the UK, France, Germany, because his advisors had told the Tsar that Russia could not keep up spending on armament. So the PCA was born under those circumstances. Now, dealing with disputes between states only. Now, if you look at a bit more closely, then you see that quite a few of those disputes between states basically involved the defense of interest of nationals of one state against the host state where those nationals had invested. Quite a few of the early cases at the PCA fall into that category. And so it was not a great surprise that in the 1930s, the PCA moved beyond pure interstate arbitration into what we call mixed arbitrations, where one of the parties is a state or a state controlled entity or an intergovernmental organization, and the other party is a private person or entity. The first such case was in 1934, involving an American broadcaster and China, where the broadcaster stated that it had an exclusive contract with China concerning the broadcasting, and China disputed that and was awarded. The award went into its favor. That was basically where the mixed arbitrations as a category were born, a category that now involves, well, the majority of the cases that are administered by the PCA, including investor-state arbitration, but not only that. Now, Professor Eriksson has mentioned indeed the legitimacy issue concerning ISDS, the efforts in the international community to come up with a better solution. The PCA has no specific view there, except that it can provide technical advice and would eventually also be able to serve as a multilateral investment court as a registry. So that is what actually is happening at the PCA. Now, if you look a bit more towards the future, you see developments that I think are very interesting. One of them is that with the withdrawal agreement, the UK and the EU, one of the dispute settlement mechanisms for that withdrawal agreement is arbitration administered by the PCA. That is an arbitration involving a state on the one hand and an intergovernmental organization on the other hand. So that's a new development, and I think a very welcome one, and it illustrates, in my view, the trust that the PCA has created over the decades in its 120 years of existence, 121 even, the trust that it has created within the international community. I think that addresses your question. I have a lot of other comments that would be triggered by what Dr. Rao and Professor Eriksson said, but I leave it at this time for the moment.
Thank you very much, Mr. Sibless. And I think that does raise some more questions and comments in the course of the discussion. For all those viewers, you're watching us live on Facebook and YouTube. At the end of this segment, we'll be happy to take questions as well, and please send in your questions. All right, let me move to Professor Rao. Professor Rao, the transboundary freshwater issues have been cropping up with increasing frequency over the past few years. It has been the general view that arbitration is a flexible and less formal quasi-legal mechanism that can actually help resolve such disputes. Yet, it has been rarely used by states in this context. Its use can arguably be reinforced, however, through the optional rules for arbitration of disputes relating to natural resources and or the environment rules adopted by the PCA in 2001. Now, what are your thoughts on the potential for arbitration to be successfully used by states in the resolution of transboundary freshwater disputes? Do you think that these rules can be supplemented or adopted in order to be used effectively in this context?
I have thought about it carefully in the light of the question you have given us in advance. You see, the river water, first of all, I want to emphasize the fact that rules are not really are not the question at all. Rules are important, as we know, as arbitrators, to play by the book when we are projecting our opinions, rendering, giving parties equal opportunity to be heard, to be involved in the decision making on at what point of time what should come, and particularly when matters of evidence are involved. So rules are important. And in the Enrica Lexi case, we have even had the unique experience of, I had the unique experience of even participating as an arbitrator where we were examining the witnesses. So therefore, rules are important. Let us never underestimate the importance of rules, because the process of arbitration starts, for your information, with a meeting of the arbitrators with the parties on the rules first, before they go on to anything else. So leave that for a moment. But the crucial point is, why would states go to an arbitration for a particular dispute? Not because there are certain rules there which are more favorable to them, or which are more flexible, or which are more economical, which are in terms of time, they expedite the matters faster for them, or in other cases, some of them go to arbitration just to waste time, you know that also. And most of the cases that have come into play in the recent years have gone from 5 to 10 years and more. And one of the reasons, it's not the fault of the PCA or the rules or the service people, the people who service the arbitration. States do go through needless motions. Therefore, the problem arises in terms of how quickly you want to get to the substance and get out of it is the issue. Sometimes the play of advocacy and political circumstances do drag on the issue in different forums, and therefore it gets, so I'm not going to those things. So the point I'm trying to emphasize, Vice Chancellor, is that rules are important, but they're not crucial. Then why are we not going to arbitration on river matters across the world? For your information, India had the experience of putting its Indus Water Treaty disputes before the arbitration, and we did have cases between India and Pakistan litigated in the arbitration. Therefore, there is an example of India doing that with Pakistan. Why? Because we have an Indus Water Treaty, Indus Water Commission, there is an Indus Water Treaty, and this treaty was concluded as soon as the parties have, the two states have been created as part of the original system of river sharing. The Punjab, the Indus Water Treaties was, unless we signed the treaties, remember, World Bank was not prepared to give the necessary aid to India for various other projects. Therefore, Nehru was under compulsion to conclude this agreement according to one assessment at one time. And just to tell you why some states have these treaties and then they follow it meticulously. Even so many wars, couple of wars and more than two situations of conflict occurred between India and Pakistan. We stayed with the treaty. We got Indus Water Commission kept meeting, and we still go to the court, and there are neutral commissions, etc. under the treaty. However, I will give you one status out of, I just checked the statistics recently. Many countries don't have the kind of treaties that we want them to have for management of the river as an integrated basin, you see. And in fact, the latest example which we are hearing in the newspapers is Ethiopia constructed a dam, and it is causing a serious conflict between, for a long time, of course, and now it has become even more serious, between Ethiopia, then you have Uganda, Sudan, and then Egypt. And now Sudan has become Southern Sudan and, of course, Northern Sudan. So 4 states or 5 states are involved in that. They don't have an agreement which is binding and which is otherwise promoting this arbitration or settlement of disputes as it arises. Number of countries don't have this kind of treaties. Cooperation is the norm. Integrated development of river basins is a scientific essential necessity, and yet political factors do come into picture, and historical, colonial, and other issues have impinged upon some of these river management. But I can also tell you another thing. If sharing of the waters is the only issue of the river water disputes, you and I know now how many floods are coming in. People don't want water actually in some places right now. And it's flooding all over the place. And one of the reasons why river water disputes don't often go to the international tribunals and particularly arbitration is, to my mind, not only the available scarcity of water and disputes arising out of scarcity of water and sharing of water on a reasonable and equitable basis has been only in lean seasons the problem arises. As you know, between Madras and Tamil Nadu and Mysore, Karnataka, when the flood comes, they throw it down. When the flood is not there, they want to fight again for the water. So this is cyclic. So the basic answer to this thing is you must have a river basin development agreements, and these river basin development agreement must take into consideration river as a unit rather than as a spatial as a resource to be separated. It should be treated as one unit and then develop it. For example, dams cannot be constructed to the lower side of the river. They can only be constructed at higher elevations where the mountains and other things where the water can be held. Once it is down to the ocean, you cannot construct any dam there. Therefore, you construct a dam where it is possible. You generate electricity power where it is most economical, and then distribute it according to shares. But that thing is not taking place. So my submission, therefore, short answer to you is, many countries don't have a river management, economic-based and integrated-based, management-based systems, and they don't have any treaties to deal with it. And most of them are dealt with in a bilateral and a plurilateral way. And I think the more commissions are established, more technical people are involved, more people's, the river-based people's needs are identified, these things get better. Arbitration is, of course, will become part of a system, and to implement system, arbitration can come in, but arbitration cannot substitute for lack of political will to settle disputes.
Vice Chancellor, let me just add that
please.
That actually to recommend for this type of situation you're describing, what Dr. Rao referred to earlier, the compulsory conciliation mechanism under the Law of the Sea, which is institutionalized under the Law of the Sea Convention, and proved extremely successful in a seemingly intractable and well, there's a very intractable and acrimonious dispute between Timor-Leste and Australia. This should be a model we should follow in the type of situation that Rao was talking about.
Thank you very much, Professor Gudmundur. In fact, I was about to ask you, something about as the challenge of small disputes. In fact, small disputes can make for significant holdings. So from Notabon to Lotus to AAPL Sri Lanka, the list of relatively limited incidents prompting far-reaching judicial and arbitral pronouncements is long. Now, the PCA's recent award in Enrica Lexi may very well now be added to this list as well. But unlike Notabom or Lotus, Enrica Lexi cannot be reduced to a timeless pronouncement that will enter the legal canon. Rather, it stands out for the breadth and diversity of matters on which the tribunal pronounced on the understanding of its own jurisdiction under UNCLOS. Now, how would you characterize the PCA tribunal's approach towards the overarching issue of jurisdiction?
Well, I should have to jump in to defend my dear friend Dr. Rao, who dissented from the decision and presented actually a very good concurring and dissenting opinion in that regard. But Enrica Lexi had also the substantive question, which you were kind of hinting at more so than the jurisdictional, which is like most jurisdictional disputes, very much case oriented. They dealt with a very important very important concept of the high seas freedoms and how is that implemented in the particular case there. And well, as you said, the cases you have mentioned led to a development of the jurisprudence per se, but also led to the states getting together to establish in a treaty-based language along the same terms. And there's very many examples in the law of the sea field in that respect.
Oh, thank you very much, Professor Gudmundur. Mr. Hugo, Ambassador Hugo Sublis, I want to ask you a question that I will respect the fact that you may not be able to give us full information relating to the, the parties' decision with regard to approaching these matters. But the question to you is that in the aftermath of the Arbitral Tribunal's ruling in South China Sea, China preferred, as we know, to settle this matter through bilateral talks with the Philippines. Now, while Pacific settlement of disputes is the ultimate goal of international settlement of disputes, do you think the post-ruling developments in this or maybe other cases indicate any concerns apropos of the future of interstate arbitration? Or this might just be the way it is and these matters will depend upon individual countries' decision to decide as to how they want to proceed?
Well, you will understand that I will not comment on the attitude and the position of parties in this arbitration that you mentioned, but it allows me the broader question to answer the broader underlying question. And in that respect, I'm an optimist. I believe that arbitral awards, interstate arbitral awards, are being complied with as a rule. That's I think important to note. And in point of fact, sometimes parties are quite happy that an issue has been solved that maybe they could have solved themselves, but were reluctant to do so because that would create all sorts of discussions in capitals about whether they had sold out the family jewels. So in that sense, arbitration is a very useful tool and it's being complied with. And again, I'm focusing on interstate arbitration. There are two cases, in fact, PCA administered cases where I think it's interesting to put the spotlight on. One is the Ethiopia-Eritrea, the boundary commission that established demarcated and delimited the boundary between Ethiopia and Eritrea as part of the political process under the Algiers Accords to allow the countries to stop their hostilities not so long ago. The Boundary Commission established that boundary, and Ethiopia decided that it could not accept part of that delimitation, notably related to the area surrounding the city of Badme. That has been the case for a very long time until the actual Prime Minister of Ethiopia decided that it was in the interest of his country to get this thing out of the way, and accepted also that part of the decision, which, by the way, made him a candidate for the Nobel Peace Prize. But it was an interesting development, even if it took time for one of the countries to come on board entirely. The other example is an arbitration involving my own country, the Netherlands, and the Russian Federation, related to the seizure by Russia of the Greenpeace ship, the Arctic Sunrise. In that case, the Russian Federation refused to participate in the arbitration, but after a while, once the arbitral award had been rendered and a compensation had been granted to the Netherlands, Russia and the Netherlands concluded an agreement, ex gratia or without prejudice to their legal positions, that led to payment of a particular amount to the Netherlands as the flag state for the Greenpeace ship. So I think there is some reason for optimism in respect of compliance with arbitral awards. That is my answer to your question. I'd like to say one or two words about the previous one, the transboundary freshwater issues. I agree with Dr. Rao that rules are not the main thing. It's political will, and the rules will follow. In fact, the 2001 PCA rules, optional rules for arbitration of disputes related to natural resources and or the environment, are rules that may apply to a situation like this, but could be amended by the parties. It's just a tool, nothing more. I would also like to support his statement that it's basically about the willingness of riparian states to agree to some system of joint management of a basin, of a common river, and frankly, I'm inclined to explain that I have been involved as a junior lawyer at the Foreign Ministry of the Netherlands. This is really a while back, with this issue involving France and the Netherlands, where French companies dumped potassium in the river, which was very harmful for the agricultural use of the river downstream in the Netherlands. So there was an agreement concluded about this basically common use of a waterway in terms of its ecological objectives, and finally there was and that was way later, an arbitration involving the two countries and concerning an aspect of that joint regime for the use of that common river that was submitted to arbitration at the PCA. This is the Rhine River, what is the name? The Rhine Chlorides arbitration concerning the auditing of accounts. You can see that there's an element of money involved, and that's not unimportant for countries here. But that's, I think, an interesting illustration of the usefulness of arbitration as a tool to deal with issues that may arise even between countries that have agreed to a common water management. And finally, in respect of Gudmundur's comment on conciliation, I cannot but agree with him that conciliation, as we have seen it happening between Australia and Timor-Leste, I think is an excellent example of what another what you would call it an informal means of dispute settlement can achieve. A commission supported by my staff spent considerable time to get the two parties to agree to a boundary, a maritime boundary treaty that was concluded under the watchful eye of the Secretary General of the United Nations, Guterres, beginning of last year. So there are various elements, and arbitration conciliation being one of them, that could be very useful in that context. Thank you.
Thank you very much, Mr. Stiglitz. Yes, Dr. Rao, I know you wanted to comment on.
Yeah. On the South China Sea, I think, unfortunately or fortunately, I had some opportunity to look into it at some stage in the earlier phase of that particular dispute. You know, first of all, the first point I would make is non-implementation of a particular award, whether it is the arbitral award or very rarely in the case of ICJ, very rarely, like Nicaragua case or something, where the awards are not implemented or otherwise accepted by the party which considers that the court or tribunal concerned did not have jurisdiction, is one thing. Where in 99% of the cases, whether it is the arbitration or the permanent courts, where parties willingly go there with a common agreement or under an agreement that is already concluded or otherwise invoked by one the party against the other, where the arbitration or the judicial settlement commences and keeps moving, and both parties cooperate in the process of putting their arguments, rarely they would reject the decision. So therefore, these are 99%. The 1% is South China Sea of recent order in this case, and Nicaragua in the earlier phase, in the earlier history, during the Judge Nagendra Singh was our president of that particular tribunal. You know, the other day you must have discussed that, and that was earlier. But then the important point is, in the case of South China Sea, there are some very, very special factors, and this is a very instructive thing to understand, that when a dispute is ripe, when a dispute and what kind of a dispute is ripe of the totality of the dispute, which is then can be carved out and be presented to the particular tribunal for decision, and how the composition of the tribunal itself and the methodology by which the tribunal conducts its business in that particular thing, and the kind of ultimate award that it renders in the light of not only legal factors but also the political factors that are involved in it. That really is a very complicated mix of brew, you know. And how do you construct this? How do you do it? You cannot define it. You have to feel it and then get into it and then somehow get through it, you see. In the case of South China Sea, there are 3 or 4 problems that occurred. One, China thought it is essentially a sovereignty issue, and law of the sea does not deal with sovereignty issues, even by the Chagos case, which recently decided that matter in favor of that sovereignty issues are not part of law of the sea. 2, the people who pushed the arbitration case thought it is essentially an interpretation and or application of the provisions of the law of the sea and not a sovereignty issue. And that revolved upon what is the status of a rock in terms of claiming necessary jurisdiction around the area. And then if there is a fundamental difference between the 2 aspects of the matter. That's one aspect. 2, the Philippines itself, following the award, did not cling on to the award as an essential means to negotiate their future, political compromise with China. On the other hand, it put it aside and started dealing with China on a different level altogether. And then 3, the Southeast Asian nations have been discussing this matter in the broader context of regional context, South Asian context, and the code of conducts are involved. 4th, the broader powers got involved in the South China Sea in order to assert their own rights of freedom of navigation. So with this kind of mix of complicated issues have jumbled up together, made that implementation, and first of all, submission of the case at the time when it was submitted, and the manner in which proceeded, and the follow-up events are very crucial why that became such a difficult issue then and even now. But this is not the same thing as time will solve some of them, as P.V. Narasimha Rao used to say, you know, when foreign ministry, when we were supposed to say, so this problem, that problem, he said, put it in the Almirah, and a few years later, it will solve by itself. This is one of those things, you see. It will solve by itself one day, but it cannot be pushed through legal mechanisms.
Well, thank you very much, Dr. Rao, for that elaborate explanation in the context of the South China disputes. Let me move to Professor Gudmunda. Professor Gudmunda, in a work analyzing the effectiveness of international arbitration, Cavendish Bull points out that in a highly dynamic world characterized by international commercial disputes, there is a certain professional competition emerging between international arbitral institutions. They compete with offers of speedy proceedings, example, emergency arbitrations, expedited proceedings, summary dismissals, and even cost effectiveness and effective enforceability. Now, while this largely applies to international commercial disputes, do you foresee such a trend in interstate arbitration, especially given the standing of the PCA and its contributions to interstate arbitration and international law?
Well, that's a very, very difficult question, but I should begin by thanking Dr. Stiglitz, Ambassador Stiglitz, for the work that the PCA has done. The example he gave with respect to the East Timor, Australia, is a very good one. They went back and forth, and I experienced their services myself. I'm on an arbitral tribunal in which the PSA is providing the registry. But this also applies. I'm not so sure we should rush to find competition amongst those great organs which are helping us whether we take ICSID or ICC or many of the other centers. They're providing excellent service, but the problem, as he pointed out, is that they don't provide the substance. They help us, the judges, reach the substance. But I think the problem is found there more than the services that are provided. And I don't see the competition so much. And I refer again to the work under UNCITRAL. We've identified many problems in the existing system. Lack of consistency, the consequential lack of predictability of outcomes, the excess duration and costs of arbitration. And then, quite important to me, is the lack of diversity of arbitrators. These problems can only be solved, in my view, and the view of many others participating in that process, through creating a multilateral investment tribunal.
If I may join.
Yeah, thank you very much, Professor Gudmunda. Just 1 minute, Dr. Rao. I want to take this particular aspect to Ambassador Stiglitz as well. Yes. Ambassador Stiglitz, do you, from an institutional standpoint, do you see this could be a potential area of, let's say, introspection from the standpoint of where PCA is?
Yes and no. Yes, to the extent that the PCA, as many other institutions, and we don't see ourselves in competition with those institutions, let me underline that. But like many other institutions, we are aiming at creating rules that help parties to deal with issues in an expedited manner. Summary dismissal included for frivolous claims. That's the kind of rules that might be still very useful to have. But then there's an underlying problem that cannot be addressed, certainly not just by institutions. That is the question of costs and efficiency. Obviously, efficiency is a technical point as well, but it is mainly in the hands of the parties. Cost as well. We have an example of the Abidjan arbitration, well known, and intra-state arbitration involving the central government of Sudan and what was then the South Sudanese People's Liberation Movement. And there was an agreement to have an award rendered within, if I remember well, 6 months of the initiation of the arbitration. That's cost effective. That's cost effective, but it's the parties that determine that. And there are certain tools to achieve that by allowing the tribunal to set limits to the number of pages that parties can enter in submission, or the time limits to be established. That's all very technical, but it's basically parties. If they throw everything they have and instruct their counsel to throw everything they have at not losing or winning, then this may take a considerable amount of time. And that's, I don't think, to the benefit of arbitration as an institution, as a mechanism, let me put it that way. It is, I think, useful to the extent that it's flexible, and that point has been made by the other panelists, and I totally subscribe to that. But it's also a matter of the parties making that happen, and that's maybe a pious wish, but it's certainly not something to be forgotten.
Thank you very much, Ambassador Siblis. Dr. Rao, of course, I know you want to respond to that, but I would also like you to answer the following question, which I wanted to have it for you, which is, many of today's professional arbitrators are so skilled that they can effectively arbitrate interstate disputes, investor-state disputes, international commercial disputes, and disputes between corporations and even other entities. Now, in performing their roles, they often find themselves bound by one of or another type of arbitral rules. Example, the PCA rules, the ICSID rules, the UNCITRAL arbitration rules, or the ICC rules. Now, in the case of Annex 7 arbitral tribunals, they've adopted their own rules of procedure. Now, since these rules vary according to context and the subject matter of the dispute, how do you think arbitrators adapt to these wide-ranging regulatory frameworks, performing their roles most effectively and with utmost versatility? Now, this question assumes significance, particularly in the context of young people who are watching this program, who may be wanting to and be aspiring to become arbitrators in the future.
I know we are coming close to 6 o'clock, and you have to end at my time, but that is your time is 8:30 already, roughly, and you want to.
We have some more time. Don't worry, please.
No. The point is, we are covering certain frontier areas actually in terms of legal evolution and dispute settlement. Professor Rajkumar, you and I and all my colleagues on the panel and many friends who are listening to us know very well that international legal system is not an organized one. And whether all tribunals, all proposals concerning settlement of disputes in the earlier years, resulting in one court or the other, have proceeded on the basis that we need a geographical representation, we need a principal legal judicial systems must be represented, we should have a variety of perspectives to be brought together with a common education, with a common perspectives to promote rule of law. Of course, that's the common objective of all of us. But then the diversity that needed to be brought into the unity of building rule of law is missing in the arbitration system. This is a point I want to get across. You go to a court, man, 15 judges coming from different countries are sitting there. You go to a class, man, you got 21 judges sitting from different countries there. All of them have same common objective. Each one is competent, each one is impartial, each one is otherwise, a standalone, credit-worthy person. But then if we have 15 Americans sitting there, if we have 15 Dutch people sitting there, if you have 15 Indians are sitting there, you want to go to that court? No. That cannot be a universal court. That cannot promote diversity in terms of promoting certain unity amongst us. That representativeness is important. In other words, the appointment of arbitrators is one of the first things that should be taken care of, and the conflict of interest in terms of promoting this particular thing is a major issue. Why certain judges, howsoever we hold them in high esteem, have to come back again and again, 100 cases, one man, one arbitrator? You don't have a good bunder there. You don't have somebody else there. I'm only just joking for the time being. I mean, I'm just trying to personalize this thing a little bit to show what we really is happening behind the scenes. And therefore, this is one of the problems. That's where the last question you asked, what is the role for Indian young people to look for a place in the sun in the system? Where will they go? If this is the kind of system that generates only a certain brand of people from a certain regions and control the, I mean, they're all good. This is nothing against them. Don't misunderstand me on this. But you have to have diversity to promote universality. The whole thing of international relations is that. And that, I think, the day the arbitration comes to deal with that, the better for it, and it will be that much quicker and stronger for every reason to belong to it and feel part of it. And that is, we must work for it.
Let me jump in on this because it's such a matter so dear to my heart. Under the proposal for a multilateral investment court under the UN auspices, there's absolutely no question that we will have equitable geographical representation. That is a non-issue in a court which is established on that basis. Slightly different problem with respect to gender balance. Unfortunately, if you look at the record of the UN, the bodies that we know, the International Court of Justice, the ITLOS, the International Law Commission, like where we are graduates and alumni. If you look at the presidencies of the General Assembly of the UN, after all this time, all these this fine language about gender diversity, how many people in these 70 years, 75 years of the UN, 70 years of the 75 years of the ICJ, 20 years of the, and so forth. How many women have been there? Less than 20. So, and this will not be done by these laudable, the wording from the General Assembly itself. We have to establish a system where this is institutionalized in the new body. And even the ICC, which is a great model, that was not found in the statute of the International Criminal Court itself. It was done by the states parties. Well, this has to be institutionalized in our new system. And I say this because, of course, I have a personal interest, you know, Vice Chancellor, in this matter. It would be a great shame if people like myself would prevent people younger and of another gender not being able to take their rightful position including the students that we're speaking to today.
Well, thank you very much, Professor Gudmundur. Oh, Mr. Sibler, please, yeah.
Yeah, it will not surprise you that I'm asking to address the issue that Professor Rao raised. I don't want to make this into a beauty contest between arbitration and judicial settlement. My simple rebuttal is that if two parties manage to solve their own problem, no one will talk about universality. It's their problem and they solve it. If they can't solve it, they may look for other means, and they're enumerated in the Charter, and running from negotiations to mediation to conciliation, inquiry, arbitration, and judicial settlement. And so although I do believe that certain conflicts would indeed merit to be decided having regard to the principal legal systems of the world, it is not a mantra that any international dispute should be solved that way. Parties could simply be interested in solving their own problem, full stop. That's my very generic and general comment. As to gender issues, I should simply say that although I sympathize with more than that, with the principle, the PCA is not normally responsible for the composition of the tribunals. It is the parties that play that role, and that is therefore their choice. And obviously there are a lot of obstacles to appointments of women and of people from diverse regions of the geographical regions. For the PCA, that's an issue to the extent that we can play a role in conjunction with the composition of a tribunal. And there are some moments that we are, and I could say some more about it, then obviously we have to take into consideration the interest of diversity in its broadest term.
Well, thank you very much, Ambassador Siblis. We are, of course, coming to the end of this program, but I can't help but ask a few questions which have come through our, through the web presence. This question I would like to ask to actually Ambassador Siblis itself. This is about, the COVID-19 situation. Several countries have adapted to the difficulties posed by the COVID-19 pandemic by resorting to online dispute resolution methods. Even cities such as Hong Kong, for instance, have introduced an online dispute resolution scheme, which requires parties to first explore alternative means of dispute resolution, such as negotiation, mediation. Given that ADR methods have adapted faster to the changing times due to their procedural flexibility, what is the future of this type of mechanism being used by the PCA itself?
First of all, let me say that obviously, like many other institutions and professional sectors, we had to shift from in-person activities to virtual activities almost from one day to the other in mid-March. We did so, I think, very efficiently. Last year, for comparison, we had 159 days of hearings in, by the way, 12 different cities, not just in The Hague. But 2020 obviously was a total, was completely different. But we have been able to move to virtual hearings and deliberations, overcoming a lot of problems, technical ones, but also sometimes related to the proceedings themselves. How do you organize, say, hearing of witnesses if you're not in the same room and you can't control the circumstances under which that takes place? Lots of technical issues, lots of procedural issues. I think we have solved them pretty well. In point of fact, we had, I think, almost immediately, and starting in July already, a virtual hearing. And since then, we have had 78 days of virtual hearings in PCA cases, which is considerable. And well, frankly, I mean, like many other professional activities and sectors, one has to wait and see whether this is permanent or whether this will stay in part. I personally believe that some activities like deliberations between tribunal members could very well take place in a virtual form. Hearings are a different situation, different case. And to the extent that travel will become possible again, I assume that that most of these hearings will switch back to in-person activities. But then the jury is still out. I think it was Mark Twain who said that predicting is very difficult, especially when it concerns the future. So I won't burn my fingers here on this, but my guess is that we will see in the future some of these forms of taking care of disputed proceedings as we have developed them over the last couple of months.
All right, thank you, Ambassador. I have the last question, and it's the same question for all of you. Let me begin with Professor Gudmundur. Professor Gudmundur, for all those students of law who are watching this program, what is that one advice that you would like to share with them regarding their aspirations to pursue a career that will be part of the international arbitral tribunals? Is this something that they should be looking forward to in the future, in which their own role and responsibilities will, as a lawyer will be shaped by the opportunity to develop understanding and knowledge and perspectives that will help them engage with international arbitral tribunals?
Well, Vice Chancellor, I cannot but go back 50 years in time to the occasion when I asked this very same question, what should I be doing in my future, to then Professor Rosalind Higgins, later Dame Rosalind Higgins, later president of the ICJ. And she told me quite simply, learn the law. Learn the law. And this is something we have to take into account as well as professors, the reciprocal obligation. But I want to add one other thing, following on what you said in your introduction and what Dr. Rao was saying about courts. Is something that we as judges should never tire of having to impress upon those who are outside our admittedly very small circle, including students that before us, to try to give them an appreciation of what happens, the dynamics within the tribunal, what kicks in when one becomes a member of an international tribunal. The esprit de cour, if I may call it such. Well, first, well, we deal with the case before us as presented by the parties. Yes, we do this on the basis of public international law as we understand it. But I feel that we are acting in response to a higher calling, the regard for the rule of law writ large. And this should be something which we should have in all aspects of international relations. And I would say, and especially in times of crisis.
Well, thank you very much, Professor Gudmundur. Professor Rao, same question to you as well.
Well, I think, again, I would say Indian students, particularly if we're talking about students in the law school and in India, I said earlier also, the more of them take to international law, the better. The more of them become ardent and passionate followers of the system and learn the system first and follow the system, like we did for 60 years now. You remember, I joined started reading international law in 1961 as part of my Masters of Law. And from there onwards, I never wavered from it. I had opportunities to go into environmental law, in domestic systems of various systems of contracts, commercial, all kinds of subjects have come up before me. And when I specialized in international law, my father was a lawyer, was asking me, who are your clients? Because those days in 60s, they know only commercial law, contract law, criminal law, that kind of law. They don't know international law clients coming to a person coming from a small town of Guntur to look for international law. But then we did it. We never wavered from it. And as Gudmundur said, we learned the law. But then we learned one thing about international law. It's not law like domestic law. It is like domestic law, but has lots of other components to it. Politics, policy, then the situations of different countries, development stages of economic growth are different. And then all kinds of things have then hit us in our eye. So that we understand law in a prism where you turn it, it acquires a different color. It doesn't have one color, one Supreme Court judge and one parliament enactment to be questioned or otherwise debated. So therefore, you must have an aptitude, you must have the patience and to work with it. And if you can become a legal advisor, first of all, a teacher, a professor has a great role to play in this thing, because that's how we came into picture, Professor Smurthy, McDougall and others. And then you have to have a good experience with the foreign office of your country, if possible, either a part of the system like I did for 30 years. And as Ambassador Rajamani said, I enjoyed every moment of my service in that system. And in fact, one of the foreign secretaries asked me one day, if you are not part of the Ministry of External Affairs, would you have had an opportunity to have as much of a variety of exposure to issues and people coming from different countries in this field, and then learn from them and contribute to them also? I said, sir, thank you very much for the opportunity you gave me, this ministry gave me. And I think if that is the source of my strength, then second thing, then don't confine, then when you become somebody else, of course we all retire and get out of it, and I trying to use our time. And then what do? In fact, Pele used to say in our law commission context and otherwise, Professor Pele, whom you know very well also, that legal advisors should be banished from any appointments in the international courts or even to the International Law Commission members. Professor Crawford one day, it's not a secret, when we were discussing about the qualifications of the judges of the International Criminal Court as part of the Law Commission discussions. He said legal advisor should not be allowed. So then I asked, yes, we have a bias coming from, as legal advisor of a government, we may bring some bias there. But at least I told him there are two things. First of all, we are underestimating the Becket principle, you know. What did Becket did? He was close to the king, but when he was appointed to the church, didn't he become the defender of church? Yep. McDougall taught us there are observational standpoints. When you're a professor, you think like one. When you're a judge, you think like one. When you're a legal advisor, you think like one. Depending upon on which apex source you stand, the perspective changes. Therefore, all you have to do is man of integrity. If you're a man of integrity, no matter which background you come from, you will perform your duty that is given to you. So therefore, I told Crawford, for your information, sir, I know you know my bias. I am an Indian legal advisor. How do I know your bias? You're arguing 22 different cases in 22 different jurisdictions for 22 different clients. What is your bias? How do I know you? I'm a known devil and you're unknown devil.
That's a good one.
In other words, the point that I'm trying to say is the personal integrity, the passion, the ultimate commitment is, as Gudmundar said, the rule of law in the world, and we have to work systemically through the system, learning the ropes. Like a gladiator, you must fight, of course, for a cause, and when the cause can be different from different purposes. And I think if we can have more of our Indian students doing that, the better for it.
Thank you very much.
Thank you, Raj. I have to add that when we're asked to join a forum like this, we're not expected to have empty minds, just not closed minds.
Absolutely, absolutely. Well, Ambassador Siblis, you will have the last word.
You know, the disadvantage of being the number 3 to answer a question like this is that most of it has already been said. So I feel kind of incentivized to be the skunk at the tea party in a way. If I look back, I note that in terms of international law or law at the international level in action has increased enormously. It has increased enormously thanks to a number of developments, political, technical, economic. When I was a junior lawyer, I think the Permanent Court of Arbitration had 0 cases, and the International Court of Justice had 1. So the Peace Palace was almost deserted. These days, and I'm talking about pre-corona days, it is quite lively, and quite a lot of young people following the Hague Academy courses in the summer and the winter. That's great. That's great. That is the good news. The bad news is that this is also subject to changes. Like, for example, the explosion of cases in ISDS since the 80s, 90s has led to a lot of disputes being solved and dealt with at international arbitral tribunals. More recently, this whole area has come under severe criticism as it being not transparent, inconsistent, fragmented, or worse, arbitrators not sufficiently impartial or independent, and what have you. And so now people are looking for a different mechanism, like the multilateral investment court. Those are developments that we don't control. And so if I look at this question and trying to think of myself as a young lawyer, I would say, don't focus exclusively on the legal profession. Legal issues don't exist in a vacuum. There is certainly at the international level a very, very important political current, or currents, plural. And that's why I'm very happy that although I started as a young civil servant at the legal department, I moved out and did different things. And in a way, I'm back now. and I have learned a lot, and I think it has made me a wiser person, and not necessarily exclusively in legal terms, but in the broader sense that law has a role to play in society, be it at the national level or be it at the international level. So my my final conclusion vis-a-vis the young lawyers or students that are listening to us, I would say if you want to have a future in arbitration, try to be as flexible as arbitration itself.
Well, thank you very much for a fascinating discussion. Thank you, Professor Gudmundur, Professor Rao, Ambassador Hugo Siblis, and of course, our host and collaborator, Ambassador Rajamani. It has been a fascinating discussion. I, for one, learned a lot. This is a very important initiative that the Embassy of India, the Netherlands, and the Jindal Global Law School and OP Jindal Global University have been doing. And I would like to extend my deep appreciation to Ambassador Rajamani for taking the lead. And also, in particular, to the three of you who have been part of this panel, not only for contributing to this panel, but also, a lifetime of contribution to this, field of dispute resolution in numerous forms and manifestations. I appreciate your leadership, your contribution, and most importantly, your commitment to the cause of the rule of law. Protection of the international rule of law to a large extent also depends upon the faith and trust and even legitimacy and credibility of these institutions that each one of you have contributed quite significantly to shape it and to strengthen it. For those, for contributions, I would like to once again extend my deepest appreciation. With those words, we would like to end this program, and thank you very much for all of you who have been part of this program.
My pleasure.
Thank you. Thank you very much.